Assalamualaikum and hello everyone. Today, Faizul, Iman, Koim and I from Group 7 will be presenting on question number 7, which is under the topic of government liability. So the issue in this question is whether the government can be held liable for the negligent act committed by Pusat Kesihatan Kerajaan Kebun Dalang towards FAD. Under the concept of government liability, it is in accordance with the rule of law that governments in democratic countries should be able to sue and be sued in the same way as private individuals. Governments participate in the community as if they are private individuals.
My name is Faiz Fahmi and I will explain on tortious liability. Tortious liability here refers to government liability towards tortious act committed by public officer. This can be seen stipulated in Section 5 of Government Proceedings Act 1956. In this provision, it stated that the government shall be liable for any wrongful act done or any neglect or default committed by any public officer. This means that the government can be sued for tortious act such as trespass, nuisance and negligence committed by public officers. However, before any action can be taken, there are some elements that need to be fulfilled, and this element will be further explained by my groupmate Koim. In the end, if all elements have been fulfilled, only then the government will be vicariously liable for the tortious act committed by a public officer.
Okay, I am Muhammad Kawim and now I will explain about the two elements that need to be fulfilled. So the first element is Section 6, Clause 1 that states that an action shall not lie against the government under Section 5 unless proceeding for damages in respect of the act, neglect or default by an officer would have laid against the such officer personally. Okay, so this means unless it can be shown that the act complained of would not have given rise to an action against the officer concerned, the action against the government would fail. Okay, the government would only be vicariously liable only if the individual is liable for the torts. The burden of proof here lies upon the person filing the suit against the government to show that the act done by the officer is in close proximity to the cause of action. However, if the action brings against the government is for negligence, then the person who is sued need to prove all the elements of negligence has been fulfilled. So there are three, as we all know, and you can see in the slide. The first is the duty of care, where the test that needs to be fulfilled is the neighbor principle, such as the relationship, for example, between a doctor and his patient, where the doctor should take all reasonable care in treating his patient. Okay, the second one is the breach of the duty of care. So when a person acts below the standard of duty of care, he is said to breach the duty of care. And the third one will be damage. So damage must exist where the negligence of the defendant had caused damage and loss to the plaintiff, for example such as injury or the loss of income. So for this case, this can be seen in the case of Muhammad Raihan Ibrahim and the government of Malaysia. So the first appellant sustained an injury when he was accidentally struck on the head by a shovel by a fellow people in the course of the practical gardening class. So basically he is attending a practical gardening class and one of his fellow people hit him in the head using a shovel. So he sued for damages, claiming that the respondents failed to provide proper supervision of the pupils participating in the gardening class and failed to instruct the people who caused the injury to him on the proper use of a shovel. And the court held in this case that the respondents were negligent for failing to take all reasonable and proper steps to prevent the appellant under their care from sustaining injury. And the respondent also did not check the condition of the gardening tools or provide a safe system of conducting the class. Therefore, the appellant was awarded damages accordingly. Okay, next, for the second element, it is in Section 6, Clause 4, which stated that the government is not liable for any act, neglect, or defaults of an officer unless he was employed by the government and paid in respect of his duty as an officer wholly out of the government revenue. This means that the officer who has acted negligently and caused injury must be a person that was employed by the government and whose their salary is paid entirely out of the government revenues. So for example, if a person works at a place that have kerajaan in it, for example, Hospital Kerajaan, the word kerajaan indicate that the place is governed by the government and therefore the person will be an employee of the government. Okay, so now the issue for the second element is whether the identity of the wrongdoing officers need to be established or not. So for this, it all depends on the nature of the cause of action. For example, in a suit for damages arising out of negligence, the officer's identity is unnecessary as the officer's negligence must be established before the government can be held liable. So this kind of case can be seen in the case of Haji Abdul Rahman and the government of Malaysia, where the plaintiff brought an action to recover damage rising out of a traffic accident caused by a driver who is driving a government car or vehicles. However, the court in this case dismissed the action as the government servant, which was the driver, was not made as the defendant. And the court held that Section 6 Clause 1 and Section 6 Clause 4 contemplate that the identity of the officer must be ascertained and the liability of the officer must be established before the government can be made liable. And this is being affirmed in the case of Kerajaan Malaysia and Lei Kitty, where it was held that in a tort, the government officer responsible for the alleged tortious act must be made a party, and that officer's liability must be established before the government can be held vicariously liable.
Limitation period refers to duration of time which the suit must be brought to the court. According to Section 2A of the Public Authorities Protection Act 1946, it stated that the suit, action, prosecution or proceeding shall not lie or be instituted unless it is commenced within 36 months next after the act, neglect or default complained of, or in the case of a continuance of injury or damage within 36 months next after the ceasing thereof. This means that any actions against a public officer for any act committed or done by him in the exercise of any public duty or authority, or for any neglect or default in execution of any written law, duty or authority need to be initiated within 3 years from the completion of course of action. After 3 years, it will be considered as statute bar.
I'm Muhammad Iman Aras and I will be explaining about the application of this case. In the application of the case of Fat, the medical officer who works at Pusat Kesihatan Kerajaan Kebun Alam has injected Fat with a dose of penicillin. Fat is allergic to antibiotic penicillin and the medical officer did not look upon Fat's medical history on allergy. Under Section 5 of Government Proceedings Act 1956, stated that the government shall be liable for any wrongful act done or any neglect or default committed by any public officer. The act of negligence that was made by the medical officer towards Fat, the medical officer could be held liable as the medical officer is a public officer. The two elements of making the government vicariously liable towards Fat are stated in Section 6 Clause 1 and Section 6 Clause 4 of Government Proceedings Act 1956. First element in the Section 6 Clause 1 of the Government Proceedings Act 1956, which the Act complained about, must be given rise to an action against the medical officer. The medical officer will only be liable if only the burden of proof made by Fat towards him is fulfilled. The burden of proof is only fulfilled when there is a duty of care between Fat and the medical officer. There is breach of duty of care by the medical officer and damage has been suffered by Fat due to the breach duty of care. Duty of care by the medical officer towards Fat exists as the medical officer has the legal duty of care towards Fat as a patient. The medical officer should look upon the medical history of Fat as it is the legal duty of the medical officer. Breach of duty of care made by the medical officer is when the medical officer did not look upon Fat's medical history on allergy and he has made a conduct that is below the minimum standard of care as a medical officer. Damage that has been suffered by Fat is the severe skin rashes due to the negligence of the medical officer, and he also lost 2 weeks of income as he was not able to run his business while in hospital. The same principle on the first element could be found in the case of Muhammad Raihan Ibrahim and Government of Malaysia, where the court held that the respondents were negligent for failing to take all reasonable and proper steps to prevent the appellant under their care from sustaining an injury and that the respondents did not check the condition of the garden tools or provide a safe system of conducting the class. The appellant was awarded damages accordingly. The second element, which is laid under the Section 6 Clause 4 of the Government Proceedings Act 1956, is the government will only be liable if only the officer in default is a government employee and being paid by the government due to his duties as an officer. The medical officer is working at the Pusat Kesihatan Kerajaan Kebun Alam and he obviously is being paid by the government as he is working at the government clinic. For the damages that Fat suffered, he needs to identify the medical officer's name and the liability of the medical officer needs to be established in order for him to make the government liable, and this principle of officer's identity is necessary as the officer's negligence must be established before the government can be held liable. Could be found in the case of Haji Abdul Rahman and Government of Malaysia, where the court held that Section 5, Section 6 Clause 1 and Section 6 Clause 4 of the Government Proceedings Act contemplate that the identity of the officer must be ascertained and the liability of the officer must be established before the government can be made liable. Fat has the limited period of time to bring this matter to the court, as it is within 3 years from the date of the injection as stated in Section 2A of Public Authorities Protection Act 1948, which is known as PAPA. So, in conclusion, the government can be held vicariously liable for the negligent act committed by Pusat Kesihatan Kerajaan Kebun Lalang towards Fed, and Fed must bring the suit to the court within 3 years from the day he was injected.